I hope everyone's enjoying our nice fall weather. Blame the lake. And hope that it gets if this continues, hope that it gets very cold very soon, because if the lake freezes over, we'll get less of this. But anyway, I'm Jonathan Adler. I'm the Johan Verheij Memorial Professor of Law here at the law school. And it's my pleasure to introduce our next panel. I will be mercifully brief. There are full bios of all the speakers in the packets. I'm just going to hit some highlights and turn it over to them, because that's why you're here, to hear them, not me. First, we will hear from Professor Heidi Kostrasser, who's Professor of Law at the University of Minnesota. Among other things, she is the author of the forthcoming book, Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution. I don't know if you can pre-order that on Amazon yet, but
I think you can.
But you might be able to. So check. Next, we will hear from Harold Krent, who is Dean and Professor of Law at the ITT-Chicago-Kent College of Law, author of, among other things, the book Presidential Powers. You may be noticing a theme here in terms of the volume of work that our panelists have done on issues relating to executive authority. And then thirdly, we will hear from Douglas Kreiner, who is Professor of Political Science and Director of Undergraduate Studies at Boston University, whose books include After the Rubicon, Congress, Presidents, and the Politics of Waging Wars, and two forthcoming books relevant to our subject today, The Particularistic President and Investigating the President. And just a warning, he is a political scientist. Apparently he may show us models and data. That's just fair warning, models and data coming at the end of the panel. But without any further ado, I will turn it over to Heidi.
All right. Well, thank you so much, Jonathan. And let me just start with some thanks. First of all, thanks to CASE for putting on what so far has been a terrific event. In particular, I want to thank the law review students who have already made this a great success. I want to thank my co-panelists in advance. I am looking forward to scintillating discussion. And I can take that back if it turns out to be a disappointment.
Too much pressure.
Jonathan Adler for moderating. And I also want to thank Peter Strauss for incredibly generous comments, as well as in the previous panel, as well as help that he's given me along the way, and support for the book, especially coming from someone who's been so influential in my own thinking about presidential power. It's very much appreciated. And I particularly appreciate that he referred to me in the panel as a younger scholar. I note he didn't say young, but he still said younger, which I appreciate. Okay, so what I'm going to do in this 20 minutes or so is first I'm going to give kind of a thumbnail sketch of indeed the book project, Reclaiming Accountability. And then I'm actually going to deviate from my original plan. My original plan was to then, in pretty typical panel speaking fashion, to then elaborate on a few aspects of the book through examples and discussion. But I found the panel this morning so interesting and thought-provoking and so relevant to the ideas I was going to discuss anyway, that I thought it might be somewhat more interesting if I spend at least some of my time making some comments that do relate to my book, at least indirectly, but that more directly are responsive to some of the discussion from this morning. And then to the extent that time remains, I'll keep a careful watch on the clock, but to the extent that any time remains after that, I'll then focus on some points from my originally planned remarks. So first, thumbnail sketch of the book project, and I'm going to take a page from Hal, who had the great idea of showing a primitive PowerPoint. It didn't occur to me to make beautiful flyers for my book. I really wish I had, but here, this is the book page. I'm sure you can all see it really well from the wrong. Oh, thank you. The book page from the University of Chicago Press, and I believe you can pre-order from Amazon. It comes out, I think, January 12th, 2015. Too late for the holidays, but I think it would make a great Valentine's gift. So All right, so thumbnail sketch of the project. I basically try to do three main things in the book. Two of the goals are descriptive. I discuss theories of presidential power I refer to as presidentialist theories, two theories in particular of very strong visions of the presidency and the underlying constitutional interpretations, and I describe them. So part of the book is simply meant to make accessible what I refer to as presidential supremacy, and that is sort of the umbrella of arguments to the effect that the president, because of the vesting clause and the commander-in-chief clause, that his judgment when it comes to matters of national security must be supreme over the other branches, even to the extent that it means that he has to circumvent statutory directives or disobey judicial orders. And the other theory you heard much discussion of in the first panel is unitary executive theory. And this is the argument that whatever power the executive branch rightly has, it must all be directly exercisable by the president, even where statutes grant that power to some other actor, that ultimately the president has to be able to make all of those calls. So part of the book is describing these theories, trying to make them accessible to sort of a broad interested audience. But then the second thing that I do that's also descriptive is I connect these theories of presidential power to government secrecy. And essentially, I make the argument that both presidential supremacy and its multiple forms, including the state secrets doctrine, the doctrine of executive privilege, arguments for a presidential power secretly to circumvent statutes, as well as secretly or not secretly to circumvent statutes demanding transparency, and supremacist arguments to the effect that the executive branch can freely punish leaks and publications of classified information with little, if any, in the way of First Amendment protections. That I describe the ways in which those various arguments help to justify and enhance and facilitate exercises of executive branch secrecy. And then I also discuss the ways in which unitary executive theory helps to facilitate executive branch secrecy, as well as relation of the information that is indeed seen by the public. And then beyond that, there's also a normative aspect to the book, which is I offer my own constitutional interpretive theory of presidential power, and specifically argue that the text itself, much as we heard Peter Strauss talk about this morning, in fact leaves a lot of leeway for Congress and the courts to place some restraints on executive power, including through transparency requirements and things of the like, and that presidential power are guided by functional considerations, including those that stem from the Constitution, and that a core constitutional principle to help guide these constitutional constraints that one can derive from text, structure, and constitutional history is what I call a principle of substantive accountability. And I argue that from a perspective informed by an understanding of substantive accountability, that in fact there's a lot of leeway for things like statutes that provide pockets of independence from presidential control throughout the executive branch, that the Constitution demands a level of First Amendment protection for whistleblowers throughout the administrative state, et cetera. And let me just say what I mean by substantive accountability. I argue that substantive accountability essentially is has two components. So it demands certainly some degree of presidential control of the administrative state, such that there's a holding a political actor, specifically the president, accountable for things that happen in the executive branch. That's the kind of overseer power that Peter Strauss refers to in much of his work. But that beyond that level of sort of formal control, a formal connection to an elected officer, that the Constitution also assumes sort of a robust accountability. That is, a degree of transparency such that people will not be able only to, kind of blindly vote for or against the president or vote for or against other elected officials, but also have some ability to know the bases on which they're voting, to know what's going on, that there be some flow of information, some ability to discover what's going on in the executive branch. And I contrast that from what I call formal accountability, which is the sort of formal control of the president over everything that happens in the executive branch, such that in theory, the president's fully accountable. In voting, people know who to blame for anything that goes on in the executive branch, but where the level of control that the president actually has over the executive branch essentially enables him to cloak much of what goes on, so that while voting can occur, it's not a particularly informed vote. And that again, that is the constitutional principle of substantive accountability that I argue can be gleaned from text, from structure, from history. And I talk about in some detail and through examples the types of constitutional or the types of allowances that makes for congressional legislation, for judicial action, as well as the types of constitutional commands that it directly imposes through the First Amendment. Okay, now that said, let me now turn to sort of a number of issues and that were raised in the first panel this morning that relate, at least indirectly, to the book project. And I'm going to basically just riff off of a number of the things that were said this morning that, again, do relate at least indirectly to the book project, and that I thought it might be more interesting to talk about and continue the conversation rather than going straight into a more detailed summary of the project itself. So first, I want to focus on something that Hal started with, which is, he referred to kind of the political realities behind presidents' actions, as well as their interpretations, implicit and explicit, of the Constitution. So he said, for example, that presidents don't really care about originalism. They care very much about the situations on the ground they're dealing with, as well as what other presidents have done, but not so much about sort of the highfalutin nuances of textual readings or originalism. Peter said something similar when he referred to the importance not just government of law, but a government of men and the psychology of office. And in that respect, I want to say I think that those points, I think those are absolutely right. At the same time, I think, that might beg the question of, okay, well, why do these questions of sort of abstract constitutional theory and interpretation matter? And I think because that forms a very important backdrop for what presidents feasibly can do. And even where presidents don't, directly invoke originalism or textual analysis, first of all, oftentimes we see that coming from other parts of the executive branch, such as the Justice Department, the Office of Legal Counsel. We'll see it manifest more directly from the president in signing statements, but also, the extent to which constitutional arguments have sort of a currency among, basically the elite legal community, right? Everywhere from academia to public discussion to the executive branch and to the Congress. Though sort of the extent to which a theory is considered credible, right, has a lot of impact on what presidents, actually can get away with. Jack Balkin, who's a professor at Yale Law School, referred to the difference between constitutional arguments that are considered on the wall, constitutional arguments that are considered off the wall, and those that are considered off the wall. And he said that among the most important things legal movements can do is move constitutional arguments from being off the wall, where they're considered, just asinine, to on the wall, where, where they're plausible, right? And in that sense, theories of presidential power, originalist arguments have played a very important role. So I talk in the book, in chapter 2 of the book, about the politics, the constitutional politics of presidential power. And I talk about the fact that, in fact, there's sort of a large investment made both within the executive branch as well as by legal movements outside of the executive branch, particularly over the last 20 or 30 years, toward making strong presidential power arguments credible. So we saw this particularly starting around the Reagan administration, particularly the period of Ed Meese's being in charge of the Justice Department, where a substantial amount of the energy and legitimacy and credibility of the Office of the Attorney General was indeed devoted to not just sort of propounding and arguing the credibility of them, but also tying it to strong presidential powers, right? Strong presidential powers as necessarily stemming from a real interpretation of the Constitution. And indeed, much of the project of the book involves sort of laying bare those arguments and those arguments as, as part of a very deliberate movement of constitutional politics, and then suggesting that they're wrong-headed. So, for example, the vesting clause arguments that Peter referred to, among other things, were developed, put forth, kind of incubated, particularly as they related to unitary executive theory, again, during the Reagan administration, during the period of the Meese Justice Department. And part of what the book does is describe those, explain how they help to justify much government secrecy, and argue that why, in fact, they're incorrect. Also, the idea of the practical importance of how presidents interpret the Constitution and what presidents do for future presidents going forward. It also relates to sort of a specific means of constitutional interpretation, perhaps associated most strongly with Justice Frankfurter's opinion that I think Peter referred to in the Youngstown case, which is a theory based on the gloss of history, that sometimes we hear arguments to the effect that because many presidents have done something before, that that sort of enhances its constitutionality, right? And we very much see this kind of argument playing a role with respect to arguments from presidential power. So, for example, during the George W. Bush administration, when the New York Times broke a story about a warrantless wiretapping program and the Justice Department issued a white paper to justify it, there were pages and pages and pages of arguments to the effect that, well, hey, previous administrations did similar things, so it's okay, right? And so this suggests sort of the dynamic and compounding role of constitutional interpretation along with kind of practical actions in the executive branch that oftentimes we'll see an action justified through, let's say, originalist and textual reasoning, but then that same action will be referred back to as a basis to justify subsequent actions. I also want to make a note about Hal's point regarding the decreasing relevance and prevalence of presidents making so-called Zone 3 arguments, for those familiar with the Youngstown case. And he mentioned correctly that you don't too frequently see presidents these days saying, we can take this action even though it would violate a statute. Rather, what they do is make arguments saying, actually our actions fall within this statute, right? And that is true, although as I point out in the book, oftentimes those so-called Zone 2 or Twilight Zone arguments come with a real sort of Zone 3 gloss. That is, oftentimes they're either explicitly or implicitly accompanied by the argument that if the statute did not allow the presidential action, then it would be unconstitutional, right? And so therefore we need to sort of stretch the statute and read it in a way that would allow this particular presidential action. So for example, one of the things I talk about in the book is that this sort of shadow of Zone 3 arguments, right, that have gained a credibility and an on-the-wall respectability through their mere repetition over time, really helped to shield President Obama when he got into office, in this sense that as a candidate, he repeatedly decried so-called war on terror episodes in the Bush administration as violating the law. As president, he frequently said, well, we don't want to have witch hunts. We don't want to be backward looking. These are really political disagreements. And I argued that without his even having to invoke Zone 3 arguments, that their mere repetition in the public sphere sort of created this sense that, hey, the political arguments are hopelessly, or the legal arguments hopelessly contested, hopelessly complicated, and sort of created a shadow in which President Obama, once he was no longer just a candidate, could stand and credibly say, well, who really knows what to do with these legal arguments? And so let's just move forward. Let's not look backwards. I also want to reference a point that was made, I think by Hal, or possibly by Peter, about the notion that foreign affairs often is an area where we have what we might call an unmediated presidency, right? Where we can often assume that actors within the executive branch are acting as alter egos of the president. But, I think it's also noteworthy that there are many instances in which in fact, the national security bureaucracy created a zone of deniability, whether real deniability based in reality or simply plausible deniability, right? Whether not so much based in reality around the president. So, for example, Iran-Contra comes to mind. John Poindexter, in fact, went on to say, having been the national security advisor at the time, that he specifically refrained from telling President Reagan certain things so as to create the possibility of future deniability. We also see this very much paralleled in the domestic realm, as both Peter and Hal talked about at some length, that there's this interesting phenomenon whereby, indeed, as we heard in the first panel, the presidency in the domestic realm is very much mediated, right? Mediated not only by the agencies themselves, but by a layer of bureaucracy within the executive office of the president. And this has all kinds of paradoxical effects, right? Because on the one hand, it creates sort of buffer agents who can, through OIRA and other means, as we heard this morning, effectively sort of champion, often behind the scenes, sort of presidential goals, but at the same time create layers of deniability, right? Now I see that I think I just have a couple of minutes left, so let me sort of connect from this to a couple of points sort of more specifically that I make in the book, and then I'll end it. Some of these examples and points of discussion from this morning relate back to one of my key arguments in the book, which is that arguments for strong presidential powers, constitutional arguments for strong presidential powers, often enable, facilitate, justify government secrecy. So, for example, I was just referring to kind of the buffer zone of the bureaucracy and the paradoxical effect that can have in creating sort of deniability, and also truly leaving the president in the dark, but also creating a vehicle for presidential control. One obvious means in which this affects accountability are through the long-standing positions of presidents, including President Obama, going way back, basically, I think, to at least the Nixon administration, to the effect that Congress cannot constitutionally require that the president or his subordinates in the executive office of the president not review or change testimony or reports coming from the executive branch. So that's one particularly striking example in which arguments about presidential power, in this case specifically arguments about unitary executive theory, can have a big and pretty direct impact on government secrecy, on the executive's ability to manipulate information. And in this regard, let me just cite one particularly striking example, and then I'll wrap up. So perhaps, although every president, since this is, since at least the Nixon administration has made this claim and has couched it in constitutional terms effectively as a unitary executive type argument, though sometimes also combined with other presidentialist arguments like executive privilege, perhaps the most detailed explanation or justification for this claim came from the OLC in the Reagan administration in 1988 in response to the White House's desire to stop or at least make edits to an informational pamphlet about AIDS to be sent to the public by the Centers for Disease Control. And I think the justification that the OLC offered it's instructive. They wrote, "The separation of powers requires that the president have ultimate control over subordinates who perform purely executive functions and assist him in the performance of his constitutional responsibilities. This includes the right to supervise and review the work of such subordinate officials, including reports issued either to the public or to Congress." And it goes on to say, "Consistent with the preceding analysis, it matters not at all whether information is highly scientific in nature. President's supervisory authority encompasses all of the activity of his executive branch subordinates, whether they be technical or non-technical in nature. Necessarily follows from the fact that the president vests," again, the vesting clause, "the entire executive power without subject matter limitation in the president." We also see, as I talk about through the book, the way in which long-standing presidential claims, again, Nixon through the Obama administration, and as we heard much discussion of in the first panel, not only to review reports and testimony, but also to review rulemakings, have a substantial impact, not just on the policies that come out of the executive branch, but on transparency and secrecy. So for example, in Peter's paper, on which his comments this morning were based, he refers to a recent study produced for the Administrative Conference of the United States, which detailed at some length the influence that the required submission of rulemakings by executive agencies to OIRA has on the length of time that it takes for the rulemakings to come out. But more importantly, for my purposes, it was very suggestive as to the extent to which this White House, this OIRA review of rulemakings often can have a real behind-the-scenes influence on what it is that rules say when they're publicly issued, on what it is that proposed rules say when they're publicly issued. We saw this of late in the FDA controversy, the Plan B controversy that Peter referred to and that Lisa Heinz about. We also saw it very notoriously in the George W. Bush administration, in the greenhouse gas rulemaking that I write about and that Peter referred to this morning. So in short, I'll stop here because I think I have taken my 20 minutes, but in short, this is, these were little sort of tidbits of examples that get at sort of one of the larger points that I'm trying to make in the book, which is that strong constitutional theories of presidential power in fact can be and have often been used in a way that undermine the principle of substantive accountability, which the Constitution actually demands, and in that sense, in fact, run counter to the constitutional plan. And I'll stop here.
So if I want to launch in, I must thank John Enton for organizing this, Tyler and on behalf of all the law review students for helping us get together and share these views. I would be remiss not to note at the outset that Heidi's book on reclaiming accountability is just won the Palmer Civil Rights Prize at Chicago-Kent. But before you clap, she's just basically standing in the shoes of Hal Bruff, who won it several years ago. So it's a nice sort of committee to be in. So congratulations. So I want to talk sort of muddy, more about that in the weeds as opposed to the hive theory, and I want to take as my sort of stepping stone that there is this kind of notion of, you talked about accountability or supervision, that the president has to care about what takes place in the administration. You focus, both you and Peter have talked mostly about rulemaking and the kind of steps and the controversial steps that presidents have taken to control rulemaking for the last 4 or 5 presidents. I want to look at adjudication instead, and that's been a much less sort of investigated area. But as most of you know, there are over 1 million adjudications take place in the executive branch each year, principally immigration, veterans, and Social Security disability, but a smattering of a wide array of others. And they have huge policy impacts, right? I mean, if to use one that's about to come out, the entire status of the NCAA may depend upon what one agency says in an adjudication about whether or not there can be a unionized of college athletes, right? You can imagine that Congress could reconfigure the whole question of the Keystone Pipeline to be a permit and therefore to be decided by adjudication. And I think all of us recognize that governments make policy through adjudication as well as through rulemaking or enforcement, because that can be through common law rules that bubble up in adjudication. It could be through factual inferences, through presumptions, and the Supreme Court has recognized the policymaking domain of agencies for adjudication as well as for rulemaking. And of course, the APA even treats them sort of on a parallel. So the question is, what about this kind of presidential control? How far does it go over adjudication? Is it similar to enforcement? Is it similar to rulemaking? Or is it somehow a different species? And how do we operationalize that difference? So I want to look first, just briefly, it gets complicated, the 3 sort of, I think, formal ways that presidents have of controlling subordinates. These are nothing that's very unusual. Obviously, as I think Hal said earlier, if you're a good president, you control a lot more than if you're an ineffective president, but at least these are formal ways to do so. Appointments clause, right? Everybody says you appoint an adjudicator, you appoint a rulemaker. That gives you control because the appointing authority has, you choose someone who's going to follow your policy preferences, has your tone, et cetera, et cetera. So, there was a case in having to do when, because the president didn't get a chance to appoint the head of the Coast Guard Military Review, adjudicative panel, and the Supreme Court said, no, it's the president's appointment. The president gets to shape what the Coast Guard Military Review does by deciding who that person should be. Now, that's an imperfect mechanism. First President Bush appointed Justice Souter, and things didn't go quite the way First President Bush envisioned. So the appointment doesn't give you necessarily continuing control, but it's an important kind of one tool in the toolkit and the arsenal to allow the president to make sure the president's policy gets followed. Now, the Supreme Court has held, didn't have to, but it's held for many, many, many years, that the removal authority follows from the appointment authority. No surprise there. And so the president gets to remove officials if the officials neglect their duties, act badly, and indeed, in some category of cases, there's a plenary removal authority as well. That's been debated all through the years. But the key point here is that the court recently has made a distinction between removal of purely adjudicative officials and all others, including those exercising a mixture of functions. It hasn't explained why it's made this departure, but it's basically held that Congress can limit the removal authority of adjudicative officials to only for cause, whereas the president has to have more control over officials who exercise either a mixture of functions, et cetera, and that's been articulated a little bit differently. Humphrey's executor to Wiener to the PCAOB case that Peter mentioned earlier. But it's important to know that in these doctrinally, the court has said there's something different about adjudicative officials. Congress doesn't have to, but if Congress wants to step in to insulate these officials from plenary presidential control, it can do so. And of course, the removal is an important tool, again, of presidential control. If you don't do what I tell you to do, as we heard about with the Treasury Secretary or the Attorney General in the Watergate case, we can remove you from authority. Indeed, some of you may know there was a case decided, I think, over the summer called Koretsky, in which a taxpayer said the whole tax-paying system is illegal because the president can remove an an Internal Revenue Commissioner, and that deprives the Internal Revenue Commissioner of the needed independence in order to assess my tax deficiency correctly. The court rejected that argument, but the point is removal is authority, and the court has made some kind of distinction. Okay, so now it gets to, I think, the more interesting part. If that's true, what kind of managerial or supervisory control, as Heidi said, must the president be able to, or can the president be able to wield over adjudicative officials, whether it's in the NLRB or in the SEC or the Social Security Administration? Well, historically, first Congresses gave president total control over what kind of adjudication to have. The veterans' claims that were given to the president, or claims after to compensate people in the Santo Domingo riots, they didn't even say what the procedure is that the president should use, so the president had to figure out, making up a procedure, making up about how to adjudicate these claims, and then doing so, and there's no judicial review. So we do have this idea of historical plenary review. But only in the last 50 years has Congress begun to create a structure or create some kind of limits, and therefore invading this inherent managerial authority, however it goes, in deciding how to shape litigation. So I'm going to talk about a couple of examples. I'd love for you later to tell me other examples I don't know about, but I'm also curious of your reaction, because I've been wrestling with this, particularly because of my study of the crashing of the Social Security disability system currently. All right, so let me give you a statute that probably very few of you have heard about that was passed in August. The Veterans Access Act, and there's a very small provision in that act, is very bizarre. Evidently, Congress was worried that people, or senior executive service, which you heard about earlier, those kind of officials have been screwing up the administration of the veterans' claims, and all sorts of veterans weren't receiving their due, and they wanted them to be punished. So, and most government employees, before they can be removed, they were subject to a hearing before the Merit Systems Protection Board, which is an agency under Article 2. So Congress said, for any senior executive service member of the Veterans Administration only that is disciplined, they can go and protest their discipline, including removal from office, to the MSPB, but the MSPB has to decide in 21 days about whether or not to overrule the discipline. And if they don't decide in 21 days, the discipline stands, and there's no appeal from an administrative judge to the MSPB as a whole or to judicial review. Totally changing the rights of one segment of the workforce. So it says, hey, this is unconstitutional. How can you do this? How can you bypass us? We're the repository of Article 2 authority here. We're the policymaking organ. You can't take this away from us. This sort of subverts the notion of what it means to be in head of employee policy for the government. So obviously this is going to be litigated, but I'll just tell you my reaction is, I think in part Congress was totally correct in trying to prescribe the procedures. The 21 days means that all these SES cases has to go to the front. The normal waiting time is probably 300 days for an employee to get a hearing. So the MSPB has to totally change it. Indeed, they have to do a whole e-filing system, which costs lots of money. They didn't do that before, just to accommodate to this congressional meddling. But if we believe that the court has said Congress can meddle more in adjudication than rulemaking, this seems to me entirely appropriate. I don't think the idea of taking away the authority from the MSPB is of any constitutional moment whatsoever. That's for Congress to decide. Congress can make that kind of infringement, if you will, upon any kind of executive discretion in terms of structuring adjudication. I do think there's probably a constitutional problem here, probably two of them, just as an aside. What are the two problems? One is, if these administrative judges now have final authority over discipline for SES employees, that probably makes them inferior officers under the Constitution. appointed that way because they're just administrative judges, but that's sort of in the weeds, so that's probably a problem. And there may be a due process problem, right? I mean, these employees, one group, only has a very truncated hearing and no right to judicial review. So we could have a due process problem as well, but not the Article 2 problem that the agency was complaining about. So again, Congress can go further in trying to stop inherent managerial efforts by the executive in adjudication than in rulemaking. Well, what about the APA, right? The APA you can look at as the biggest way that Congress has taken a step to try to limit the way the executive branch adjudicates disputes. And as many of you know, because of the fact that you can't have performance reviews of ALJs, you can't dock their salary, and so forth and so on, people have said this is a kind of decisional independence that structures the way the executive branch has to do adjudications where the APA applies. The APA doesn't apply to the MSPB, but the APA applies to Social Security Agency, to the NLRB, SEC, and so forth. So I think that that is, again, a permissible intrusion, and that the courts then should defer to Congress and say, at least give broad brush or give a kind of leeway to say that this ideal of decisional independence should be recognized. Well, is this all theoretical? It's not all theoretical, because these disputes are arising in the immigration, well, especially in Social Security Administration, and have for many years. So these are some old examples. I'll give you some new examples, but the old examples are in the 1980s, there was a concern that the grant rate for Social Security disability had been increasing, and so that we needed to have reform. So the administration decided they were going to investigate more clearly Social Security administrative judges that had higher grant rates for claims than lower grant rates. And they also decided to investigate more hearing offices that had higher grant rates as opposed to lower grant rates. And this sort of Bellman review problem program went on. That seems to me that a court, they never had to really resolve this, but a court would have said that's a violation of the APA, because we want to assume that when Congress enacted the APA, that it wanted this decisional independence, and whatever management Congress can give, the executive branch can give, how you schedule cases, who writes the decisions, what your timelines are in order to get the decisions out, you can't interfere with the decision itself. And that's just one kind of rubric to give. What about the question of trying to discipline ALJs who are late? Their output isn't big enough. There's a lawsuit going on right now currently based upon the fact that these kinds of quotas are a violation of decisional independence of the ALJ. It'll be argued, I think, next week in the Court of Appeals. I think, again, under my sort of rubric, that's not within the APA. That there, it's hard to draw lines, but there the idea of having, it may be crazy to have a quota of how many cases, and by the way, you may be shocked, the goal is about 600 cases a year for Social Security ALJ to resolve. It's a lot of cases, right? And how careful can you be when you're resolving 600 a year? That's another story, but that's for the executive branch to do unless Congress intervenes. But if Congress says you can't impose that quota, Congress has that right, because it can, again, I think it can, the lesson of the Supreme Court's cases now, their sort of weak unitary executive theory is that, for reasons I could speculate on later, Congress can interfere more with adjudication than with rulemaking. Well, what about if the agency says, wait a second, what about an ALJ that just gets it wrong, misunderstands the Social Security Act? I mean, it just blows it. Can't we get rid of that ALJ? That's just good management, right? We want people that represent us and know how to apply the law. That's a tough case, but I think the answer is the APA should be given this buffer, and they should say, remove an ALJ for getting it wrong. That's too dangerous. That's to getting the nose of the camel under the tent, because then ALJs will be worried about pressure to be pro-government for fear of being removed under the guise of getting it wrong. Indeed, in the immigration context, which is not covered by the APA, there were a series of incidents under the second George Bush where immigration judges said just that. They were removed and threatened to be removed for getting the asylum issues wrong. So I think the APA should be taken to give a cover for that. One more, or maybe two more examples, then I'll stop. One example is there is a agency rule of the Social Security Administration that you can't disparage anybody in your opinion. You can't disparage the agency, you can't disparage the claimant, you can't disparage the claimant's attorney. Well, you can imagine ALJs sometimes disparage the agency. They say, you didn't give us enough time to write this decision, or they say that the record is not full because you made me get this out of the door within a matter of 30 days, et cetera, et cetera. And they've been disciplined for being critical of the agency in their opinions. Again, I think my lens on the APA and decisional independence says you got to at least keep this decision as hands-off, and the agency should not be able to discipline an ALJ for anything said in this case. So in these current controversies, I would side with Congress and the APA protecting the ALJs. Not with respect to quotas, not with respect to scheduling conferences, but anything tied to the decision itself, because Congress has made that intrusion into how the executive branch structures it. I also, just as a tail end, the last thing I'll mention, I think my perspective gives a new sort of understanding of why an old case that some of us have wrestled with called Portland Audubon Society makes sense. I'm sure Heidi will like it, because it held that in an adjudication that any kind of ex parte contacts between the administration and the ALJ would be prohibited, even though the APA arguably doesn't say that specifically. The APA, the president is not within the term of an agency within the APA, so why is then the president a person which cannot give ex parte contacts during the pendency of an adjudication? And my lens on this, or gloss on this, is because that's what the APA is all about. It's all about this decisional independence, keeping the integrity of the decisional independence for ALJs, and I think that that's permissible even under the modified unified executive as embraced by the current Supreme Court. That's it.
Okay, so the obligatory thanks again to everyone at the Law Review and my host here at Case Western. Thanks so much for opening your doors to a couple of political scientists. It's really a fantastic opportunity for me to be in this type of interdisciplinary setting and to get so many ideas and different perspectives that enrich my own work, and I appreciate it very much. So this is part of a new collaborative project that I have with Dino Christensen, a colleague of mine at BU in the political science department. I think actually that in this setting, I might be preaching to the choir today, which will be a little interesting. I think if I gave this talk in one of the presidency sections at APSA, I'd get a lot more pushback. So please bear with me if this doesn't seem as provocative as I had hoped, perhaps. So here is a quote from our august speaker, recently reelected, right, from July of 2014, right as he was about to announce that he intends to sue the President of the United States for overstepping the bounds of his constitutional authority through his unilateral action. So Boehner said, sort of casting Obama as somehow uniquely unilateral in his modus operandi, that the current president believes he has the power to make his own laws, at times even boasting about it, which he's done in back-to-back State of the Union addresses if you go back and look at the text. He said that if Congress won't make the laws he wants, he'll go ahead and make them himself. In the case of the employer mandate and the Affordable Care Act, that's exactly what he did. So Boehner is overstating things a little bit, of course, in terms of trying to single out Obama as somehow different from his precedents, getting back to Hal's point about presidents looking to the precedents of the people who came in ahead of them. So presidents have acted unilaterally, of course, since the dawn of the Republic. Washington's Proclamation of Neutrality gives us the Pacificus Helvidius debates. Jefferson, the Louisiana Purchase. Lincoln does all sorts of stuff unilaterally, culminating in the Emancipation Proclamation with that neat caveat that he said he had no power, despite Chase wanting him to free slaves within states not currently in rebellion. Assertions of unilateral power never went away, but they became particularly explosive again after 9/11. So military tribunals, enhanced interrogations, Geneva Convention rights, NSA warrantless wiretapping, all of this stuff seemingly even more shocking perhaps because Congress was in such a giving mood. Why did President Bush not choose to just ask for more authority while he would ask for some and he'd take others on his own? And then President Obama, despite promising a shift in tone and a shift in posture, has largely adopted similar policies in the foreign policy realm, but also approaches, relying heavily on unilateral tools. So he's changed, as Boehner mentioned before, the implementation of the ACA in key ways. He's implemented much of the DREAM Act, which he was unable to get through Republican Congress through administrative memorandum. And he's conducted unilateral military strikes in Libya and Syria, with some of the OLC opinions really going far beyond, I would argue, in many ways, prior precedents in terms of carving out a very aggressive view of what presidents can do without having to seek any congressional authorization. So the dominant paradigm in the political science literature is that this is perfectly clear why presidents do this, because presidential power, while not unconstrained, is incredibly, incredibly broad and very difficult for other branches to check. So presidents enjoy a wide range of tools in their unilateral toolkit that they can use to materially affect the course and content of public policy. The issuance of significant executive orders, and there could be an entire hour on how you go about trying to measure which executive orders are significant, just like which again, but pretty much any way you slice it, this seems to be something that's increasing a lot in recent decades. So much so that sort of the unilateral politics side of our field has argued it's sort of the quintessential feature of the modern presidency. It's what makes modern presidents modern. And this increasing reliance has led both within scholarship and within the punditry to sort of the emergence of a new imperial presidency narrative. And so what I'd like to do today is sort of push back and try and flip the paradigm on its head. And I'd like to ask, if presidents' unilateral power is so great, the puzzle to me is not why they do stuff like Boehner is alleging, but why they use unilateral action so relatively infrequently. This is not to say that presidents don't exert any influence while acting unilaterally. All of the examples that have been given thus far today show that in many cases, plainly, they do. But I would argue that they just don't use it with quite as much regularity as we would. So to sort of to do this and set up my critique, I'd like to spend a little bit of time looking at formal models, which is quite ironic as I am in no way whatsoever a modeler. But it's sort of the general framework that most of the political science scholarship on unilateral powers has employed. So I'm going to start off just by illustrating very briefly a basic median voter model of legislative behavior. Then Keith Crabill's pivotal politics model, which has then just been adapted and turned into a unilateral power politics model that tries to show why presidents are able to get so much of what they want unilaterally. And that's most associated with William. So a median voter model, real quick, the setup of my simple unidimensional spatial model. Imagine, I don't know, that we arrange members of Congress on a single dimension and say some are more liberal and more conservative than others. It's intuitive. We do this all the time. And political scientists have even given people nice little numbers between -1 and 1, so that, you know, Mary Landrieu may be a -0.1, and, you know, Ted Kennedy may have been a -0.8. He's pretty far on the left, and I don't know, I always used to say Strom Thurmond, but, you know, maybe Rand Paul is somewhere about a 0.8 or something like that, and we can array people on this line. The real beauty of the median voter model is that we say we don't even have to know where anyone but one member of Congress is. All we really need to know is who's the person right smack dab in the middle, because if we assume majority rule, that's the person who's going to matter, you know, is how that median voter is going to vote. And once we know that, we can figure out what's going to happen when something comes to the floor of the United States Congress. I'm going to simplify and say that we've got a unicameral Congress for a moment. So let me just give you a real quick example. Say that we have a leftover status quo policy passed by Speaker Pelosi. It's out there on the left. Voter in Congress now that's fairly centric. And say Speaker Boehner introduces Bill B that tries to move policy towards a more center-right direction. What's going to happen? Well, the median voter just simply, I prefer. I'm closer to the bill ideologically than I am to the status quo. The median voter votes for the bill, it passes, policy moves. That's all we need to know. You can sort of figure out pretty quickly, intuitively, that if we had multiple rounds of voting, what's going to happen is policy is always going to converge to the preferences of the median voter. And this really is largely the model that economists and political scientists use to think about legislative behavior for 30, 40 years. Along in 1997 comes Keith Crable, and he says this doesn't describe the polity that we have. There are lots of different features that aren't captured in this simple model, but one of the most important is that we've got some supermajoritarian requirements built in. In the United States Senate, we have a filibuster. It used to be something that wasn't used all that much, but it's used pretty much all the time now, formally and informally when it's not actually having someone out there speaking. So we know that there are going to be times when a minority of just 41 senators is going to be able to block legislative action. We've also got the presidential veto, right? The president has to be incorporated into this model, and if the president vetoes a bill, now who's the pivotal player? It's what's called the veto pivot, right? The 34th member of, or the 67th member of Congress, the 34th closest to the president's position. That's the person you've got to win over to compile the 2/3 majority necessary to overturn the presidential veto. And so this is what we're left with now. We've got sort of two main key players, the filibuster pivot and the veto pivot. So what happens in this new legislature? Let's say a status quo here of sort of center-left. We introduce a bill that pulls policy in a more conservative direction. Median voter likes it. M is closer to B than to SQ. The president likes it. If the bill passed, he'd sign it. But it's going to tick off the minority, right? The liberal minority is going to be able to filibuster this bill. It will filibuster this bill. Policy doesn't move. What if we sort of flip things around? We've got a much more conservative status quo policy than what the median of the chamber would want. The median voter is going to go ahead and vote for this bill. There probably won't be a filibuster, but what's going to happen when it gets to the president's desk? He'll veto that bill. What's going to happen? Will the veto be sustained or will it be overridden? All depends on V in our model. V prefers status quo to the bill, so the status quo stays. What we end up with then is this result that there's something called a gridlock interval. Between the filibuster pivot and the veto pivot, if you just run this game over and over and over, you'll find that nothing will ever happen to a status quo policy that's lodged in this area. As we enter into an era of polarized parties, right, you can imagine that if we were to array people out and their ideological preferences, this gap, this gridlock interval has grown significantly over time. So this makes getting anything done in Congress really, really tough. That sort of echoes recent experience, I think, especially over the last 4 years. And then along comes the unilateral politics people, and they sort of turn this thing on their head. And they say, you know what? This does make presidents' task really, really difficult about getting Congress to give them the type of legislation that they want. But that same difficulty really redounds to the president's advantage when he's acting unilaterally. So how does this end up working? Consider this scenario, which is exactly the same as this, that one. I'm just going to move it a little bit this way. So we've got the same status quo before, which was frozen. There was no way to change it, to move it towards the president's preferences through law. But now the president comes along and issues an executive order. Says, I'm going to make this policy closer towards my preferences. What happens now, right? Well, could the median voter try and move policy back towards a more liberal direction in this case? Yes, but the president will veto it, and his veto will be sustained. So we're left with this interesting result that if presidents can move policy and keep it within that gridlock interval, they can to their preferences, and there's no possibility, according to the model, that Congress will ever be able to enact to undo what the president has done unilaterally. We've heard a lot of speakers thus far talk about first mover advantages for presidents, and that's exactly sort of what this formal perspective leads to. So the veto gives presidents tremendous advantage when acting unilaterally. Does Congress have the possibility to constrain unilateral action? Of course it does. But because of the structure and the institutional setup of our system, Congress is only in very rarely, in rare cases, is it going to be able to undo legislatively something that the president has changed unilaterally, and then only if presidents have been stupid, pardon the bluntness of it, and moved policy too far. Anytime that they keep it in that gridlock interval, Congress is not going to be able to act. Courts can strike down unilateral actions. However, empirically, they very, very rarely do so. And there's some data on that, but I'm going to mainly focus on Congress here today. So what we're left with is this assertion by most of the literature that presidents' capacity to change policy unilaterally is just extraordinarily great. But the real paradox here is in frequency. Regardless of how you try to measure it, presidents at most are issuing a handful, 5, 6, 7 executive orders that even merit mention in the New York Times anywhere on any given year on average. So, when you compare it to the amount of lawmaking, when you compare it to other sort of metrics, it's just not all that much. And so what we argue then is what is puzzling is not the frequency with which presidents use these sorts of national security decision directives or executive orders or proclamations to really affect major changes in policy, but it's really the paucity of these actions that sort of puzzles us. And so this leads us to, I think, a place where a lot of some of the talks that have come before have sort of also been touching on, which is that there have to be these informal constraints on unilateral action. And so if we move beyond the sort of narrow confines of the formal modeling literature, we want to argue that presidents do a lot more than think about whether or not Congress can introduce and pass overriding his veto legislation to undo a unilateral action. They also care more about whether the court, about more than just whether the courts are going to strike down and it's going to be upheld by in subsequent appeals to finally force presidents to abandon something they've done unilaterally. Rather, presidents are also thinking about the long-term political costs that a unilateral action may generate. I'd say there are 3 main types. One is, sure, you may carry the day on the specific issue where you acted unilaterally. Congress may not be able to overturn you. But undoubtedly, there are going to be other programmatic priorities in your agenda that you're going to need Congress for, and Congress may exact their revenge on you then. So Richard Neustadt's famous book, Presidential Power, back in 1960, sort of made exactly this point, but it's, I think, in many ways been forgotten. He has this chapter called 3 Cases of Command, and in each case, including the Youngstown decision, the seizure of the steel mills, the president gets exactly what he wants, at least for a time being. But it comes at longer-term political costs in terms of all of their other preferences. And that may be enough to dissuade presidents from not acting when they otherwise could. Public opinion is key here, too. It may turn against a unilateralist president. We've got a lot of experiments that are in the field right now that are going to try and really understand how the public thinks about unilateral assertions of power by presidents. And if this happens, it would erode the president's, a major source of presidential political capital. And then finally, I want to bring these 2 together, and I'll show you some data for this, that opposition by Congress and the courts, even if it fails to result in formally overturning a unilateral action, can have a significant political cost by swaying public opinion against the White House. So in the paper, we sort of look at 2 case studies. Immigration, which I guess Drudge might, sort of to use a Drudge Report headline, I could probably put ... developing or something like that. We'll be rewriting it in the weeks to come. And also some of the president's response to chemical weapons and the use of chemical weapons in Syria. So in each of these cases, I think there's a tremendous amount of evidence that Obama is very, very sensitive to the political costs of any form of unilateral action. And he's making complicated cost-benefit calculations. After trying the legislative route and even coming out and saying that he doesn't have the power to do much on immigration in various cases. As the election approaches in June 2012, all of a sudden that constitutional power was found, right? And we get the DACA. And sure enough, now again, famously Obama said, I think in 2013, I don't have the power to do that in response to a protester calling for him to halt deportations. It looked like he was going to act earlier in the summer. Now we've delayed it until after the midterms, after sort of threats by Republicans to hold the budget hostage and pleas from red state Democrats. So here's a case where Obama may well get a lot of influence from acting unilaterally. But it may be one of those rare cases where we sort of see, look at the costs. And in many other cases, he may determine that yeah, these costs outweigh the benefits that he's likely to get. Syria, I think, is another interesting case in that way. You know, Obama, by all accounts, had made the decision to order military strikes against Assad about a week after the attack was confirmed, and he changed his mind in the 24 hours before the Rose Garden address. Some pundits have been quick to say that, you know, oh, Obama rediscovered his constitutional scruples. No way. In the address, he makes no bones about it. He said, I have the authority as commander-in-chief to do this on my own. But in a press conference a week later, he was really, I think, prescient about it and open. He said, if Congress doesn't authorize this strike, you know, they're going to do what they want to do, which is sit on the sidelines and snipe. More if things don't go all that well, and less if they do go well. And that's sort of where Congress is comfortable. And this sniping can have real political costs. It made a lot more sense to try and bring Congress on board. And so why is that? I think it really is because of public opinion. It's sort of the mechanism by which sniping, hearings, investigations. I can't believe I'm agreeing with Newt Gingrich, but he had an op-ed in CNN today talking about sort of these different tools that Congress has available that are totally underestimated. And I think he's exactly right. So let me just give you some data for why that might be, because presidents care intensely about public opinion. So I want to give you some evidence that other branches may be able to increase the political costs of acting unilaterally. To do this is sort of only conducted about a week ago. We embedded an experiment on an online survey that was administered to about 600 adult Americans, and subjects were randomly one of 3 treatment groups that varied the reaction of other branches to a proposed unilateral action on immigration. So here's the prompt that everyone got. Efforts at enacting comprehensive immigration reform in Congress have failed, and as a result, Obama is considering new executive action to give legal status to many undocumented immigrants, et cetera. Everybody gets that, the basics of what's going on. Then subjects are randomly assigned to one of 3 groups. In the control, they get nothing else. In the first treatment group, many members of Congress oppose this decision, arguing that unilateral action is unconstitutional and a violation of separation of powers, and the president really must go to Congress to actually change the law. And then in our third treatment, we put in that many experts warn that the Supreme Court may strike down such an action as unconstitutional. All subjects are then asked the exact same question: would you support or oppose President Obama acting unilaterally to change the nation's immigration laws? So I'm going to spare you the more robust statistical analysis. I'm just going to give you the differences in means across. In the control group, support for unilateral action is about 55%, almost exactly the same as what's been observed in other similar surveys that have been out there. In the Congress treatment, when they're told about congressional opposition, Obama loses about 10 points. You can imagine how the media would wreak havoc with this, right? On the one hand, it's a majority of Americans back the president. On the other hand, he's only in the 40s, just about with where his own approval rating is. And in the Supreme Court treatment, sort of consistent with the literatures on judicial legitimacy, the figure is even lower. So just to wrap up then, almost on time, the statutory and legal constraints on presidential assertions of unilateral, as characterized in the literature, I think, are indeed weak. This is exactly true. However, the political on the aggressive use of unilateral power may be considerable, and much more considerable than often acknowledged, if not in law, as it sounds, maybe much more so in political science. And these political constraints, which are sort of outside of the dominant formal modeling approach that we as a discipline have used to think about unilateral politics so much, may explain why presidents use unilateral action so relatively infrequently, even though the range of policy areas in which they know they could act without Congress being able to undo what it is that they've done unilaterally is really great indeed. And so one last point then, just to respond to something that Heidi raised, transparency is obviously key for this because public opinion is such a key mechanism in our argument. So when you move into the realm of national security decision directives and place things that are hidden from public eye and public scrutiny, and you're not able to have this informal political process playing out, the informal constraint that we're emphasizing so much here is going to be a lot weaker. And I think sort of the claims of those arguing for a much more robust unilateral executive are on a much firmer footing. So thank you.
First, before we go to questions from the audience, I was curious if any of the panelists on each other's remarks? If not, then I'll steal the moderator's prerogative to ask a question and to start by picking on the political scientist, not for disciplinary reasons, just because. One of the claims in the discussion is the idea that unilateral executive action is relatively rare. And my question is, or initial part of the question would be, how do we measure that? Because one common claim that, or basis for measuring that is cited is, for example, number of executive orders. Sure. But a lot of the things we're talking about, executive orders aren't relevant, right? So the delay of the employer mandate enforcement, no executive order. The fix to the problem of health insurance plans losing their grandfathering status, not even anything remotely approaching a rule. It was a memorandum from CMS to state insurance commissioners. Both arguably significant unilateral action. And the former arguably unilateral action that, at least by some interpretations, transgresses what would have been one of Congress's traditional ways to constrain the president, that being setting a specific date certain that a law takes effect in a statute, right? That is kind of one of the traditional kind of action forcing ways that Congress may try to constrain discretion. So given that that's part of what we're talking about, how do we know whether or not unilateral action is increasing or decreasing? And I guess relatedly, and the other panelists may want to address this, does the fact that the model has this realm where the president really can act without worrying about being overridden, and that this may include acting against formal constraints acted by Congress, should that change the way we think about the propriety of the judiciary playing a role in that? And so I'm thinking, perhaps is this perhaps a justification for the House lawsuit, which I will admit I'm very skeptical of, but that model kind of says, oh look, Boehner might have a point because they did what they normally should do, set a date certain. The president just said that he's not going to abide by it, and Congress structurally can't do anything about it.
Sure. So to answer the first question on measurement, absolutely. And I think our literature on unilateral powers for so long sort of has focused exclusively on executive orders, and clearly that's missing a ton of stuff. I think DACA even is through executive memoranda. There's no order, I don't think, attached to that. Right. So there's a lot of stuff that's being done that's not through sort of the same tools that have been used as much in the past. And so, measuring is going to be difficult, and I certainly agree that in all of these things that it's been increasing and that it's been important. But if you want to consider, I think sort of to go back to one of the questions before, the actions that were not taken, I think that we could sit down and sort of still devise a large number of policy areas in which Obama is not, at least in any way that sort of is being picked up in the mass media, acting unilaterally, where conceivably there's plenty more that he could accomplish. That's not to say that he's not accomplishing a great deal in the areas where he's chosen to focus. And in immigration reform, if he pays a political cost, he's probably willing to entail that. He's like, this is a victory that I want, and so I'm going to do it, and I'm going to pay whatever price there is. Point taken, but I still think that if you consider all of the universe of cases in which presidents could conceivably act unilaterally, that in the vast majority they still are not. They're eschewing it that way. And on the question, just real fast, of judicial constraints, so some of the models have taken into account judicial discretion and have generally concluded that it's very, very wide. So I think all of that's pre the ACA ruling and some of the others. And so I wonder if we aren't seeing the beginnings of a more aggressive court. And absolutely, I think we're to the point where I think it reminds me of like the war power of sort of some of the war powers resolution literature as well. Like, how far does Congress have to go? Like, if they pass a joint resolution and it's vetoed by the president, will court step in then? And I think that sort of where you're putting such a burden on Congress to actually successfully legally overturn one of these things, that you could really still have the seeds of quite a constitutional crisis, and you are calling for the judiciary to step in.
War powers is a good example, right? Because the courts have not relaxed their traditional approaches to justiciability, even in cases in which you would have thought the courts were skeptical of the executive's position. They've still said, hey, leave us out. And I don't know if the other panelists wanted to.
I just have a quick, go ahead.
Oh, no.
And it's just that, I think Doug's presentation reminds us that there are political constraints as well as, legal and constitutional constraints, and I think we know that. I agree with your analysis. And I do think that Boehner's lawsuit was frivolous, but I think the notion of people withstanding, challenging presidential action on the ground that there's no basis in the Constitution is not unheard of, and I think we might see more of that in the future.
I guess the issue is if the actions are such that no private party would have standing, and the employer
Well, it's a
may or
different-
may or may not fall into that category. It may just be that those have standing have their own reasons not wanting to sue.
Right. And that would take, it's a different kind of debate, but that would take us very far if the court decided to hear cases in which no one would have traditional case or controversy limitations. That would be a very big departure and would shift the balance more towards the judiciary in terms of being an arbiter of powers.
Yeah, and just a few things to add. I mean, sort of in keeping with what Hal just said, certainly to the extent that you have a group withstanding to make a challenge and the argument is that, statutory or constitutional power was exceeded, I think that's how the system should work, right? It just becomes a case-by-case question of do the actions have any merit. Just one kind of tangentially related thought that comes to mind is that there is a role, a lot of the types of conflicts that could make their ways to the courts between presidents and Congress involve things like, for example, executive privilege, right? Even though that's not what this is about, but it comes to mind. And that's where some sort of framework statute, I think, actually could really play an important role in helping to channel challenges, so as to kind of balance the relevant interests. And I think part of the reason we haven't had such a framework statute, part of it is, just simply the difficulties in getting anything legislated. But I think part of it really is sort of the shadow of these constitutional arguments, the questions of would such a law be constitutional? And I think there's kind of an ironic result, which is that if such a law were actually crafted, the president, given his veto power, given his bully pulpit, could actually, have a lot of say in terms of protecting his interests in such a law. But, the shadow of things like executive privilege concerns, I think, help keep it from being passed. And actually, just one more thing, kind of on the note of the shadow effect of constitutional arguments, I think that also plays a role in actions that presidents might take or leeway that they have without actually having to make constitutional arguments about why they can take this or that action, right? That oftentimes just the ubiquity and credibility given to arguments that, well, the president can do this or that, kind of gives a patina of credibility to unilateral actions. And also, while absolutely, congressional pushback, as you talk about, can have big influence, there are at least some contexts, even when we have divided government, where it's really not in the political interests of people in Congress to push back, right? So not always, but often that's the case with national security, right? We saw this in the George W. Bush administration after 2006, even when we had divided government. There were a lot of realms in which I think the shadow of these arguments to the effect that, well, maybe it wouldn't be constitutional for Congress to push too much for information was kind of a political godsend to a lot of Democratic members of Congress who really didn't want to get into this.
Questions? Here comes the mic.
Oh, I have what I hope will be a short answer question for each of you. Starting with you, Doug, I wonder why your sample didn't include a fourth and fifth question in which you suppose that either the majority of Congress or the courts were thought to have supported the matter. And, I would intuit that you would get then 65 and 70, where you otherwise got 40 and 45, and so wonder whether you aren't just reporting the impact of the unfamiliarity of your sample group with what the law might or might not be. And how, it seemed to me in your presentation, you assumed that the Public Company Accounting Oversight Board case only addressed the exemption of adjudicators. But as I recall the case, the court said, well, we assume that the SEC commissioners are protected from removal except for cause, And of course, that is a body that exercises every function of government. And on that assumption, the court rested with its conclusion that all powers of the PCAOB were constitutional and affected ratification of everything else the PCAOB was doing. So I wonder if the case can be quite as limited as you imagine it. And Heidi, I wonder how you respond, how in your analysis you respond to the tension that is that's created by, let's say, Truman's remark, which I that the presidents absolutely have to have private advice, and if they can't have confidential advice, they can't get advice.
Which order?
Doesn't matter.
Why don't we go in order of?
Okay, so real fast, absolutely. Support does help the president, although there's so many hardcore, I won't approve of anything that has Obama written on it, that it doesn't help as much as criticism can hurt. This is just a really simple experiment. You know, there are others that we've done. It matters who criticizes, whether it's Democrats, Republicans, both, and it also matters whether the criticisms are constitutional versus policy-based. So all that matters, you know, and there will be book chapters that sort of walk through all the different pieces, but thank you.
Yeah, and just a brief thing, I think the PCOB case is strange because in terms of reading into a removal provision for the SEC, which wasn't even there, and so that makes it, you know, even stranger. So I don't want to speculate on that, but I just want to focus on the one part which said treating adjudicators is different. So you may, the other things are going on, but still I think the case clearly says, and that's what the dissent points out, wait a second, how, it doesn't make any sense. And it's incoherent, but then I think there's actually a theory there, which you can criticize, which to the court, accountability is accountability in the public eye. And I think what the court is saying is public doesn't expect adjudication to be traced back to the president the way it expects rulemaking enforcement to be traced back to the president. So we view that differently, and I think that's the underlying motivation of the court in making that distinction.
And that's also in Myers.
Also in Myers, that's correct.
Yeah. So I completely agree with, you know, the basic point that unfettered openness is certainly not desirable, but, you know, for a variety of reasons, including national security, but certainly given the candor concerns. And in many ways, you know, my constitutional arguments sort of captured that point because many of my arguments are directed toward the notion that Congress has a wide zone of constitutional leeway and discretion in terms of what types of control or secrecy or openness constraints they place upon the executive branch and upon presidential power. So, you know, getting back to what I said a few minutes ago about, for example, a hypothetical executive privilege framework statute, right? If such a statute were in fact to be crafted, you know, it would almost certainly not entail or require complete openness from the executive branch, but in part because of the president's role in shaping legislation with his veto power, you know, would build in, you know, a lot of presidential discretion to keep his own a secrecy. You know, and I argue with respect to unitary executive theory that there is some floor on Congress's ability to estrange the president from administrative controls or from administrative officers, but also they have a wide range of leeway in terms of shaping relationships between the president and administrative bodies. And that includes taking into account policy considerations about the benefits of secrecy as well as openness. And I think, kind of as I alluded to a minute ago, I think there is some irony in the fact that one thing that the ubiquity of arguments that call into question Congress's ability to pass statutes governing things like executive privilege or the administrative state, one irony of that is, you know, it prevents Congress from creating legislation that actually would almost certainly build into the statute zones of discretion for the president.
Other questions? Peter?
So I wanted to give Doug an example and then ask a question because, well, just, and forgive me if you addressed this a little bit, I was out for just a moment, but it's obviously a lot of, well, obviously or not, there's a lot of uncertainty about what kinds of presidential action count as unilateral.
Sure.
And a number of things that are discussed as presidential unilateral initiatives are perceived within the executive branch as being within broad discretion, but discretion nonetheless vested by, implicitly or explicitly by statute. So there's always this question about whether it ought to count as unilateral. But one great example, I think, that tracks your approach perfectly was actually alluded to by Peter earlier, and that's so that the biggest administrative law institutional innovation of the last 30 years, 35 years, is the creation of this system of presidential regulatory oversight, starting with Executive Order 12291. And there was an issue originally as to what, if anything, the executive order could tell independent agencies to do. So this is cut completely from whole cloth. There's no statute that authorizes the president to create a system of presidential regulatory oversight over regulation. Originally, the Department of Justice, building on a law review article written by a younger version of a law professor sitting immediately to my right, advised the OMB that it would be okay to tell independent agencies that they have to report information and respond in procedural ways, but that they couldn't the president could not substantively dictate that independent agencies follow certain regulatory policies. And so that was the advice they got. The Reagan administration decided to do nothing with regard to independent agencies. And this is purely a calculation of political cost as to Congress. And when they published the OLC opinion, they just deleted the section that says you can go after independent agencies. And in the change to go after independent agencies on the informational point was only made by the Clinton administration, which basically perceived that unlike the Reagan administration, they would not be facing a hostile Congress, so that they could go at least this far in terms of talking to the independent agencies.
Yeah, so I guess a real brief response then. In the investigations book, which I've almost finished up, we have a case study chapter, one of the case studies in one of the chapters is about EPA and Superfund cleanup stuff, which is going on about the time of the regulatory review. And here's a great case picking up on something that Professor Strauss said before, right? How is Reagan pursuing policy change? He, sort of ditches the Carter-esque administrator and puts in someone who's come straight from industry with Burford Gorsuch, and I think he's acting probably legally within sort of statutory discretion, and Congress doesn't really care, right? They have a lot of hearings, and they haul people before Congress, and we get executive privilege claims, and you end up with a Republican-controlled Senate still supporting some legislation at the end. So you've made the veto player sort of agree to push the administration, and even before Congress acts, Reagan just basically caves, and he fires Gorsuch. He brings in Rickles-House back and dusts him off. And if you look at it, there's here's the pattern of enforcement. Then Congress starts to intervene, and even before any law is passed, all of a sudden it's like whoosh, shoots up. And so I think it does fit well, sort of the way in which even though presidents have gotten a lot of additional control or asserted additional control over a regulatory agency, is sometimes when Congress kicks up a fuss, they pull back rather than pay the costs.
Alrighty, well, I think we are out of our allotted time. We have a 45-minute break, I believe, for lunch, right? Lunch will be in one of the rooms back across the hall, and we reconvene back here at 12:45. So again, please join me in thanking our panelists.